order. Good afternoon and welcome to today's meeting of the Joint Committee on Human Rights. We're a cross-party committee of both the Commons and the Lords, and a joint committee of both. Today we're taking evidence from Michael Tomlinson, KC MP, the Minister of State for Countering Illegal Migration, and it's really the concluding part of our inquiry into the human rights of asylum seekers in the United Kingdom. We're very grateful to the Minister for joining us, and also to his two officials who are with him, Simon Ridley, the Second Permanent Secretary at the Home Office, and Joanna Rowland, Director General of the Customer Services Group at the Home Office. And our questioning today is really going to focus on some key issues such as the UK-Rwanda partnership, the provision of accommodation to asylum seekers, and the placing of unaccompanied children in asylum hotels. We only have an hour due to timetable constraints today. So, Minister, if we don't cover all the grounds that we were hoping to cover, we might follow up with some written questions at the end of the session, and I hope that will be all right.
Madam Chairman, I'll do my best to answer them in writing as well, if not better, than I might have done in person.
Excellent. Thanks very much. Right. Well, can I just ask you, Minister, to give us an overview of what role human rights play in the formulation and the delivery and monitoring of the United Kingdom's asylum policy?
Well, Madam Chairman, perhaps may I start by thanking you for extending your warm welcome to me and to my officials from the Home Office. I understand the time constraints that you're under. Therefore, I will hope to strike the right balance between giving sufficient detail and not giving too much in terms of volume, length of answer. Let me answer your question in a very straightforward way. In my view, the government and the Home Office treats this in the same way that any other department would in relation to human rights. It's important, of course it is. We're dealing with human beings, and every single day that I wake up, I remind myself of that fact and the importance of doing so. So I neither understate it nor overstate it. It is important. It is part of the system.
In our reports on the Illegal Migration Act and the Rwanda policy in general and the Rwanda Act, this committee has repeatedly warned that many aspects of the government's policy, asylum policy, risk breaching the European Convention on Human Rights and therefore the Human Rights Act. And we have said, because it's true, that that is the overwhelming weight of the expert evidence that we've heard. And in fact, it's been quite hard to find anyone with legal expertise who disagreed with that conclusion. Can I just ask you how seriously you take that?
Well, I take the committee's reports incredibly seriously. I hope and I know, in fact, because I know your personal diligence and I know the committee's diligence, and that you will have examined the responses that I personally gave to the committee's report in relation to the safety of Rwanda bill. But I don't think it's right to say that everybody, either on the committee or those witnesses appearing in front of the committee, accepted or adopted the same position. I think actually it was quite nuanced and quite fair in some of the paragraphs in bold. Some of the conclusions that were drawn were actually nuanced, if I may say so, and rightly so, because as a lawyer, and there are a number of lawyers in the room, as a lawyer you will know that there's quite often room for argument and room for where different opinions can be perfectly legitimately held, legitimately argued, but a dispute can still remain. And I suspect when it comes to the end of this session, that may well be where we end up.
But I want to be clear that it was the overwhelming weight of the evidence. There may have been nuance, but it was the overwhelming weight of the evidence we heard that the policy itself and both the Illegal Migration Act and the Rwanda Act were in breach of international human rights law. That was the overwhelming weight of the evidence.
Well, can I say, let's take a specific example rather than speaking in generalities. So let's, as your report did, and as your report quite rightly did, you tackled the question of section 19(1)(b) as part of your report, and I hope you saw I know you would have seen my response to that. And there is a dispute. You'll have seen my reference to the Communications Act back in 2003. It's not new, it's not novel for there to be a 19(1)(b) statement. In fact, dare I say it, although I wasn't in Parliament and neither were you at the time, that's the reason why Section 19 was drafted in the way that it was, because it was envisaged that we may well end up in a scenario like this. And I know that you're wanting to hurry me on, I understand why, but in relation to the 2003 Act, it's worth noting that the United Kingdom was actually successful in arguing that that case did fall on the right side of the line, even though at the time the bill was published, the Secretary of State was not in a position to give it a 19.1a statement. And dare I say it, that's where I believe that we will end up in relation to this bill as well.
Well, let's take another specific example that's perhaps a bit closer to home. We had the decision of the Northern Irish High Court earlier this week, which ruled, in addition to matters pertaining specifically to the Good Friday Agreement and the Windsor Agreement, it also made declarations of incompatibility between aspects of the Illegal Migration Act and the Human Rights Act. Doesn't that rather vindicate the position that this committee has taken and vindicate what was the overwhelming weight of our evidence?
Well, respectfully, no, because we're at the first stage of the litigation, if you like. You will know as well, if not better than anyone in this room, that that was a High Court decision. That was the first stage. You will see in the Prime Minister's response, and I know that you've engaged in this and followed it very, very closely. This isn't the end of the story. It's rather, it's much more likely to be the very beginning of the story, and the government in general, and I personally am firmly of the view that in the exchanges that we had during the course of the passage of the bill, that our position is right. But there will be further stages, if I may say so, through the court process.
So will the government respect the rule of law and not take any steps to deport anyone under the Rwanda scheme until the relevant avenues of appeal in these cases are exhausted and it's clarified that such removals would be lawful?
Well, respectfully, Madam Chairman, as you know, we're dealing with two separate things. Firstly, we're dealing with, so the court case that you're referring to is dealing with the Illegal Migration Act. That's the first thing. What we're dealing with at the moment in terms of getting planes off the ground, if you like, as part of the Prime Minister's mission and my mission to stop the boats, what we're dealing with is before the IMA has come into force, ensuring that flights can get off the ground. So the short answer to your question is yes. At the moment, the IMA is not in force. The Illegal Migration Act, parts of it, let me nuance that. The duty to remove, the Home Secretary's duty to remove in Section 2 of the Legal Migration Act is not yet in force. And to that extent, absolutely, until that duty is in force and the scheme is up and running, there will be no deportations under that Act. But let me be crystal clear. We are preparing to make sure that flights will get off the ground. The Prime Minister's timetable has stayed the same, and nothing in Monday's court case changes that position.
Under what authority will the removals take place then, if not under the Illegal Migration Act?
They'll take place under the Nationalities and Borders Act and the Safety of Rwanda Act.
Now, if there were to be a legal challenge to the Safety of Rwanda Act, and if there were to be a finding at first instance that the Safety of Rwanda Act was incompatible with the Human Rights Act, would you respect the rule of law and halt any removals under the Rwanda Act until you'd been through the appeal process and exhausted it?
Well, we would respect the judicial process, as of course the government repeatedly does and always does. So you mentioned Monday's court ruling. Actually, the formal handing down of the judgment, as you know, will be 2 weeks hence. That's when an appeal can be lodged, and that's the proper process. And the government will go through the proper process. But may I say it, Madam Chairman, I'm an optimist. I'm glass half full. I believe firmly that this legislation is on the right side of the line. It's been carefully drafted to ensure that we fulfil our international obligations whilst fulfilling the aims of the Prime Minister and I believe of the British public, that we need to stop the boats coming off the channel, and part of that is getting the deterrent effect up and running, and that's the Rwanda scheme. And I know there's a political difference, there will be, inevitably in a cross-party committee such as this. But in terms of the legal process, of course the legal process will be followed, and I suspect you're right. I suspect there will be a challenge, but I firmly anticipate that robust arguments will be made that this legislation has been drafted on the right side of the line.
Please don't misunderstand me. At this point, I'm not making a political point. I'm making a legal point.
No,
that
I agree.
the overwhelming
I widened it. I expanded it.
But my point was really that the overwhelming weight of the evidence that this committee heard from legal experts was that the Illegal Migration Act and the Rwanda Act fell on the wrong side of the Human Rights Act, and we've been vindicated by, in our view on that, on the Illegal Migration Act, by the finding of the court in Northern Ireland on Monday.
Well, thus far.
Thus far.
Thus far.
Okay. Can I ask you about the Prime Minister's speech on Monday? Because he said, and I quote, "If the Strasbourg court make me choose between the ECHR and this country's security, I will choose our country every time. Can you explain what you meant by that?
Well, what I mean by that, when I say, let me not put words into the Prime Minister's mouth yet, let me use my own language, and I've used similar language in the past. What I mean by that, what I would mean by that, is that we have drafted legislation, as you know, in the Safety of Rwanda Act. We've drafted Clause 5, now Section 5 of the Act, which means it's for a minister to decide, for a Minister of State to decide and to make and take that decision. I believe that's constitutionally proper. I think that is perfectly appropriate, and it's now part of the law, part of the parliamentary sovereignty aspect of the law that we debated so much during the passage of that bill, both at second reading and also in committee stage. So in my view, the choice will be very, very clear, and I think that's what the Prime Minister has said as well, and I agree entirely with him.
It's really his words. I mean, I'm not putting words in his mouth because these were his words.
You're reading them out very clearly.
If the Strasbourg court make me choose between the ECHR and this country's security, I will choose our country every time. Yeah. That seems to me to go a little bit beyond what you're saying, and I just wonder, does it signal that it would be government policy to derogate from the ECHR if necessary, or does it signal that the government are contemplating leaving the ECHR if that's necessary to deliver the government's asylum policy?
I think it signals the Prime Minister's determination and my determination to make sure that planes do get off the ground, to make sure that this Act does work in the way that it's intended to work, that the deterrent will be up and running, and that the European Court, the ECHR, is not going to get in the way of that. That's why the legislation was drafted in that way. That's the whole purpose of putting Clause 5 in the bill in the first place. And I know there are commentators, and in fact during the course of the debate, saying actually it's not an unorthodox position to have that. That is the straightforward constitutional position, that it will be for a minister to decide. And you may have heard that it will be this minister that will be part of that decision-making process. And I'm very clear about how I'll go, and I'm very clear how I'll go about that process.
So we shouldn't read anything more into the Prime Minister's words than just what you've said just now. It's not indicating that the policy's moved on to derogation or leaving the ECHR.
Forgive me, Madam Chairman, you should read nothing more nor nothing less into it. It's a determination that this is going to work, that we are going to make this work regardless of whatever may come flying at us. Clause 5 has been drafted, so it will be for ministers to decide, not anyone in Strasbourg. The Prime Minister has been clear, and I'm very clear as well.
Does anybody else want to come in on that issue?
I would be, I'd like to press you a little, because there has been, not just domestically and not just in one political party, but even amongst leading Conservative lawyers, a great deal of concern expressed about not just the constitutionality of the Rwanda Safety Bill Act, but about interfering with our international treaty obligations. And that concern has been directed at the ways in which statements, a bit like the one that we've just heard come from the Prime Minister, are playing a game of doublespeak, which is, on the one hand, throwing a bone to those who don't like human rights and don't like the European Convention on Human Rights, and indeed don't much like any of our international obligations that might involve protecting the humanity that you spoke of when you first entered the room, being one of those things that you wakened every day to think about. But one of the issues of doublespeak is that it's sending a message which is, we're not going to be taking any instructions from the Strasbourg court. What would you do? What are you expecting to happen if someone makes an application to the courts and on an individual basis is saying, I will face harm because I will not be safe because of the particular issues affecting me if I am sent to Rwanda, and the court thinks there's a prima facie case that they would like to hear around that, and there is a desire by the Home Secretary to put that person straight onto a plane and shunt them off to Rwanda. And the European Court decides that actually this is precisely the sort of case where there could be irrevocable harm, irredeemable harm, irreparable harm to the individual. What's the answer to that? Do you just ignore the European Court? And if so, what would the consequences be?
Well, Barrister Kennedy, as you know, my previous role was as His Majesty's Solicitor General, and I saw cases that came in front of my desk on a daily basis, sometimes on an hourly basis. And the way that I conduct myself, the way I always have conducted myself, that comes before me. But I see no contradiction between adopting that approach and the Prime Minister quite rightly indicating a determination that we are going to get planes off the ground, that this policy is law, it's passed, it is an Act of Parliament, it's on the statute book, and our determination to make sure it works and to make sure that planes get off the ground. So I see no conflict. I understand the tension that you're highlighting, but I personally see no conflict in that whatsoever.
But it's more than a tension. If an application is made to a court, a British court, which has then still got to determine the outcome, the decision that a British court would make as to whether this person is going to be unsafe if they're sent to Rwanda, and therefore Europe puts a stay on the person being put onto a plane and says we're putting, a special measures to prevent that person being deported to Rwanda, then there's a choice being placed before the minister. Do you ignore the courts, and therefore just ignore law, and send out the message to the world that you're prepared to ignore law? Or do you just say put him on the plane, send him there? What do you do?
There are two stages to that. Firstly, the first part of your question relates, I think, to Section 4, Clause 4 of the bill, of the Act, as it is now. Incredibly tightly drafted. I think that was the wording, the judgment of this committee, that it was only very narrow exceptions, in exceptional circumstances. Forgive me, I don't have the precise wording from this committee's judgment, this committee's report on it, but several witnesses emphasising quite how high the test is, how high the bar is, how high the barrier to overcome in order to succeed on an individual. Let me finish, because
that will reach that barrier.
How high that is. But it's also been drafted in such a way as to mirror the words, the tests that the European Court themselves will be grappling with when determining whether to give an interim indication or not, namely the serious and irreversible harm, exactly as you quite rightly outlined. Almost mirroring the words. And we've even seen in the last few weeks, in the last few weeks a movement from the European Court in response in part to what's happened recently, to move closer to our position. And I think that's right. I think that's healthy. That is a good thing. But it doesn't take away from the Prime Minister's determination, from my determination, to make sure we get planes off the ground. I see it all as part of the same package. It's part of the same bill.
That's rhetoric, Mr. Tomlinson, our determination to get things off the ground. Now, we know that you're determined to do that. But what are you going to do if a court, and the European Court particularly, but if a court is still determining the issue here in Britain, and an effort is being made to get those planes off the ground with that person on it, and the European Court says we're going to make an interim measure in this case because we're persuaded that that high bar has been reached?
What am I going to do?
What is your answer?
My answer is I will look at it on a case-by-case basis, as I have done throughout my career.
Thank you. You will retain the rights.
We look forward to it.
As a member of the executive, to override a court decision.
I will retain the rights and the powers and the authority as given to me by Parliament and as passed in Section 5 of the Act of Parliament.
Does that not sit just a little bit uncomfortably with you as, like me, a member of the bar, a KC and an officer of the court? You will substitute your judgment for a court's judgment?
Not at all, quite the opposite. We're fulfilling the will of Parliament. We have an Act of Parliament. We are following precisely the legislative steps that have been set out by our sovereign Parliament. It's the exact opposite. We grapple with these things in practice. We grapple with these things in Parliament. And no, not at all. This is exactly the constitutional position that we find ourselves in. A bill is presented, the bill is debated at second reading at committee stage. It's an Act of Parliament, and the bill and the Act will be followed.
Parliament is always supreme, even if Parliament legislated to say a cat was a dog. That would be
Well, respectfully, I never liked that metaphor, a cat is a dog. That seemed to me to be taking it a stage too far, adding a bit too much colour, a bit too much rhetoric, even for Baroness Kennedy, perhaps. So taking it a little bit too far, I think. Quite the opposite. In this case, what it was doing, what the legislation was doing, was responding to the situation as it had been after the summer of 2022. So quite the opposite of the analogy that you tried to draw.
Simon.
Thank you. Yes, there are many instances, aren't there, Minister, where ministers have to exercise a view on matters which may otherwise fall within the purview of the courts. And one could say that returning the power to you and to the administration under the provisions of the Safety of Rwanda Act to ignore Rule 39 indications and similar powers in the Illegal Migration Act, that simply returns the position to that which was prevailing when the European Human Rights Convention was signed, i.e. that Rule 39 indications were just that, indications to contracting parties to decide whether or not they wished to implement the decisions. So in many ways, it's more of a purist view of the convention, but it seems to me that it's entirely proper that you should be able to take that decision. Would you agree?
I think that is a very strong argument, and you can broaden that out and say that ministers more generally make quasi-judicial decisions all the time. As I say, perhaps uniquely in the Law Officers Department, that's done on a daily, if not hourly basis. But other ministers, am I going to take an example? Let me not take a specific example, Madam Chairman. But other ministers take quasi-judicial decisions regularly, and this will be no different from that. And Lord Murray, I think you make a very astute observation in terms of the history and how we got to where we are in relation to Rule 39s.
Yeah, equally, you could say that a court that's not in a position to issue interim orders to preserve the status quo while a determination of the facts is made is not much of a court.
That's not what the legislation says.
The courts of my jurisdiction in Scotland would cease to function if they couldn't issue interim interdicts. The courts of your jurisdiction here in England would cease to function if they couldn't issue interim injunctions that people actually took cognizance of. But what you seem to be quite comfortable with is the European Court of Human Rights, a court to which we are signed up to, being rendered really impotent by you giving yourself the right to decide whether or not you personally decide to override their interim orders.
Well, to use your word comfortable,
court, really.
To use your word comfortable, I'm very comfortable, extremely comfortable with the constitutional position that we have introduced a bill, that we've passed an Act of Parliament, that Parliament is sovereign, that it says in Clause 5, Section 5, that it will be for a minister to decide. And that's, if we get to this theoretical position, if we get to this theoretical position, then it will be for a minister to decide exactly as it says on the statute book, and that is constitutionally robust and proper.
Okay, just moving on, staying with the Rwanda policy, I just want to ask a couple more questions before I hand over to somebody else. The 2023 saw a significant fall in the number of small boat crossings compared to 2022. But as of April, 21st April this year, 6,000 people had crossed the channel, and as of 7th May, I think it's 8,700. And that's up more than a quarter compared to the same period last year, and it's the highest ever figure registered for this period of the year, as I understand it. Now, this is happening despite enormous publicity across the world about the Rwanda policy over the period really of the last 2 years, and intense publicity during the passage of the bill. Doesn't this really unprecedented increase suggest that the Rwanda policy is not the deterrent you hoped it would be?
No, not at all. You're absolutely right to highlight the success last year, reduction by a third, despite the increase across Europe of between 60 and 80%, depending on which point you take in particular. That was absolutely a significant success to those who are exercising those decisions 12 months ago. And let me just highlight, because I returned at 1 o'clock this morning, Madam Chairman, from Albania, let me highlight the Albania scheme. As a particular success. Well, let me explain that. I will answer it.
But hang on, we don't have much time, Minister.
You're right.
I'm not going to quibble with you that the Albanian scheme has been a success. But what I'm interested in is this significant increase in the number of people crossing the channel this year suggests that the Rwanda policy, despite the huge international publicity about it isn't acting as a deterrent. Now, can you
Okay.
dissuade me of that?
Let me dissuade you in this way. We are early on in the year, so therefore it is too difficult, it is too soon to say definitively that these year's figures are going to be X or Y, because we simply do not know. They could in fact be Z, and neither X nor Y. So let's wait till the end of the year and see where we are. In terms of the deterrent effect, well, we saw 2 weeks ago, perhaps 10 days ago, in terms of Ireland and our Irish friends and what happened there. There is the deterrent effect in action the very day, within hours of the bill coming into force. There is the deterrent effect in action. We heard evidence during the course of the second reading and beyond at committee stage as well, of those from the Home Affairs Select Committee who spoke to people in France who said, if you go, do you know that if you come across, you could be sent to Rwanda? No, we don't want to do that. This is all evidence that was put before Parliament in relation to this bill and how the deterrent effect would work. But let me agree with you in part. The whole purpose of the Act is to ensure that we can get planes off the ground. Not just one plane, but a series of planes. And that is when the full effect, the full impact of the deterrent effect will kick in.
Okay, when this committee visited Rwanda earlier this year in February, and I asked one of the government interlocutors how many people they thought they could take, and they said that they could take up to 2,000 this year and then up to 10,000 over 5 years. Now, 97,000 asylum seekers arrived in the UK in the year ending June 2023. When you bring the Illegal Migration Act into force, there's going to be tens of thousands of people left in limbo because you can't send them all to Rwanda. What are you going to do with these tens of thousands of people who are going to be left in limbo?
Well, there are several things, several aspects to your question. Thank you for mentioning that the committee has visited, and I heard from a number of you who visited the different responses and reaction that you got on the ground. And that was actually very valuable to me as the Minister, who hasn't been in the luxurious position that you've been of visiting recently, although I did visit a little while ago. In terms of the capacity, let me make a political point, and then I know it's a cross-party committee, so I'll move on from that very swiftly. The accusation was that Rwanda could only take 100 or 200. What nonsense, completely scotched by this committee's diligence in finding out. Well, let me make the political point, then I'll move on.
But hang on a second.
No, it was suggested only 100 could be taken. It was nonsense. Absolute nonsense. Uncapped.
2,000 per annum is a drop in the ocean of 97,000 per annum. So I'm just wondering what's going to happen to the other people who, after you bring the Illegal Migration Act, will be in limbo because they can't apply for asylum. At least most of them can't.
This committee's evidence scotched the Labour nonsense about the limit on the numbers. It is an uncapped
Hold on a minute. There's only enough housing at the moment for 100.
So it's an uncapped scheme. So what's going to happen with the thousands? The whole point of the Rwanda scheme is that it is a deterrent. The whole point is to stop people coming over here in the first place. It's not, it is not just looking at it from one angle. You need to look at it from stopping those who are coming across in the first place. And of those that are already here, it is not just Rwanda that is the country to return to, but their home country as well. And dare I say it, last year 26,000 people returned to their home countries as well. So let's put it in the context and in the round as well. I'm very grateful to this committee for the work that it did in scotching that nonsense about the limit that there would be.
I think we've got your point on that, Minister.
Well,
this committee wasn't the source of those figures.
But it publicised it very effectively and
But
very
there's
well.
still a very valid point to be made that if the Rwandans on their own say-so can only take 2,000 per annum, there's going to be quite a lot of other people who have to be accounted for. But I don't want to dominate
the 26,000, I think, is a good
so I'm going to bring
answer.
in David Alton and then Lord Dallachia. David.
Minister, thank you very much for the evidence you've been giving us. Can I ask you two questions? One is about the individuals involved, those who are sent to Rwanda. If there are still outstanding questions about the legitimacy of them having been sent there, and if we get into this quagmire that you've been describing of legal battles that can continue sometimes for years, what rights will they have once they've been sent to Rwanda? What will we do to ensure that their individual cases can then continue to be assessed? And my other question is about the 114 million people displaced in the world. We're looking at countries like Sudan at the moment, where there are now some 11 million displaced by the war over the course of the last year. You said that there's been some movement in Europe towards the government's position. I want to know what the government is doing to ensure that there are real international efforts to get at the root causes of mass migration, because otherwise this legislation, as the Chair has indicated, it will look like a drop in the ocean in comparison with the scale of the problem.
My Lord, thank you very much indeed for your Lordship's question. It's a very important one. It is important to look at this in the round. It isn't just Rwanda. We are also returning people to their home country as well. But as you know, the challenge is where it's not possible, in those circumstances where it isn't possible to return people to their country of origin, to their home country. That's where the Rwanda scheme is particularly important. May I say so, your observation of the 114 million people who are on the move is a very astute one and a very important one. It was part of the West Balkans conference yesterday. That was the theme of it, because we know the Western Balkans is one of the routes where hundreds of thousands of people pass through, and that's why that's why it's so important to tackle it. But respectfully, encouraging or having anything that will encourage that mass movement of people across borders is one that should be discouraged. My view, my personal view, and I think some may share this, is that it would be strongly preferable for people to claim asylum in the first safe country that they reach, rather than risking their lives on dangerous crossings. May I just say this very briefly, because we talked about humanity. People have been dying in the English Channel every single month. This is why I am personally determined that we must ensure that this policy works.
Sorry to interrupt, David. I'm a bit perturbed by this idea that people should seek asylum in the first safe country, because if you look at the stats, according to UNHCR, 70% of asylum seekers are already hosted in neighbouring countries to their countries of origin, and there's only 30% who are on the move in the way that you describe. And of 30% that are on the move, the United Kingdom isn't even in the top 15 countries in Europe for asylum seekers per head of the population. So what I don't really understand is, why do you think other countries in Europe, 15 of them, are able to cope with a higher volume of asylum seekers than the United Kingdom without resorting to legislation that potentially breaches international human rights law, or without resorting to sending them to Rwanda?
Well, Madam Chairman, respectfully, even if the figure is a third, and I accept what you say, but it is still the total, as Lord Alton quite rightly said, a total of over 110 million, 114 million, I think was the figure given. That's still 36 million people who are on the move, and respectfully, it is appropriate to claim asylum in the first safe country. No one who is in France is in an unsafe country. That is why they should not be putting their lives at risk, giving their money to these people traffickers, spending thousands of pounds on people who don't care if you live or die. I think some of the members of this committee have seen the boats, the condition of the boats.
Nobody is making any excuses for that. My question specifically was, why do you think 15 other countries in Europe, some of them a great deal less wealthy than the United Kingdom, are able to cope with more asylum seekers than us without resorting to passing legislation which potentially breaches human rights law, or without sending them to Rwanda? What is it about the United Kingdom that we have to take such extreme measures when other European countries are not doing that?
Well, Madam Chairman, respectfully, part of your question is contested, because we had that exchange as to whether it does or does not breach international law. We had that exchange at the outset, so that's an assertion but not a conclusion. I believe that we are a generous and open and welcoming country. Look at the facts, look at the evidence. Over 500,000 people since between 2015 and 2023 have been rightly welcomed into this country under different schemes. But dare I say it, in terms of being a welcoming country, part of that is ensuring that we are welcoming people here under schemes that we have seen that are up and running, rather than coming across here illegally, taking routes that are dangerous for them and unacceptable for us. That is why we are determined to clamp down on these criminal smuggling gangs. We are a welcoming country, Madam Chairman, and that figure of over 500,000, in my view, speaks volumes.
There are many other countries that are more welcoming than us. But anyway, David, did you want to...
My real question was actually about international cooperation.
Yes, thank you.
Because really what I was driving at, Minister, is that if we treat people as though they're part of a sort of pass the parcel, somebody else's problem, This is going to go on, and whether they should be welcomed in one country or another isn't really my point. It's what are we going to do to tackle the root causes of this mass displacement? Why aren't we driving things on, for instance, as we do with climate change, with the international COP conferences and so on? Is the government giving thought to how we bring together countries to say this isn't just your problem or our problem, this is the world's problem. We've got to tackle this in a much more coherent way. With the generosity, for instance, of something like the Marshall Aid Programme, the things that we did when vast numbers of Europeans were on the move when the ECHR came about in the aftermath of the Second World War. We did a lot of things, whether they were practical or legal, we put those into place. And I agree with you about the generosity of our welcome, for instance, to the Ukrainians, to the Hong Kongers. We are capable of good deeds as well. So I'm not making any partisan point here. I'm just wondering, what are we doing to tackle the root causes? Because the bill itself is not going to solve that.
My Lord, no, I recognise entirely. I have made some political points, if you like, but I don't see any political points in your question, and it's a perfectly proper question. I mentioned to the committee that I was in Albania for the past 48 hours. That is part of the cooperation between our two countries. Let's not just take the Albania scheme. Let's widen it out to the Western Balkans. Actually, that is part of the cooperation that can happen, and the investment that can happen, not just in the channel, if you like, but further upstream in order to prevent exactly the scenario that you're talking about. International cooperation is absolutely crucial. The Home Secretary himself made a speech in New York last month, it could even have been 6 weeks ago now, talking about the global cooperation, that's starting a global conversation with our international partners. That is absolutely right. This is the issue of our day. This is the issue of our time. 100 million people, whether they're just moving just across the border to the first safe country or moving further afield. We need to make sure we have grown-up conversations with our friends and allies. And in fact, in all of my meetings with my international counterparts, that's exactly what we're having. And dare I say it, by introducing the Rwanda bill, we have helped to start that conversation or reinvigorate that conversation and that debate with our international partners, and I think we'll see further movement as well.
So with the Irish government, for instance, was referred to earlier on by the Chair, I mean, what conversations are we having with them to resolve this? So again, we don't get into this invidious position of saying, well, it's now your problem rather than ours.
Well, respectfully, that is a very good point. The common travel area, of course, is unique in relation to Ireland and Northern Ireland, but we should be having conversations, whether it's with France, whether it's with Ireland, or whether it's with the Balkan countries, whether it's with Italy and Greece. I was in Tunisia, in Libya as well, seeing those launching, trying to get across to Italy from Tripoli, and incredibly important that we work with organisations such as the IOM in order to support them to encourage more people to stay in the region rather than risk these treacherous journeys. I do agree. This is part of an important conversation that we must continue to have.
Thank you.
Thank you, Simon. And
Thank you
then
very much.
Navnet.
If I may, Minister, just two questions. You mentioned other external interest in third country processing, particularly in Europe. Perhaps you could just outline where we are with that and who is looking at the scheme and what you know about that. And the second point was you were asked lots of questions by the Chair in relation to the numbers that can be taken by the United Kingdom. To what extent do you think the integration of the refugees into the delivery of services should feed into consideration of an upper limit on the number of refugees the country should take, and what steps are being taken to use the cap provisions that were contained in the Illegal Migration Act?
My Lord, thank you. Very, very good question. Obviously, sections 60 and 61, I think I got that right, of the Illegal Migration Act in terms of the cap. And the legal migration minister, I think on Monday, confirmed that there will be legislation, there will be a statutory instrument that will be brought forward by recess, where evidence will be brought forward as to the local authorities' response and what that number should be. And as was committed several times to Parliament, that evidence will be brought forward, that will be debated in the usual way. And it is a hugely important part of the conversation. We talked about, I know there's a variety of views, we talked about the generosity of the British people. But the generosity may be infinite, but the capacity is not. And that's exactly why Minister Persclave has been doing his job of liaising with local authorities, seeing where the capacity is, and will be bringing forward that as quickly as possible. And I think the commitment was given by recess as well. So that was the second part of your question. The first part are what other countries are looking. I can't say any more than I know that there are several countries who are very acutely interested. Perhaps it's too grand to say that the eyes of the world are on this scheme. There's a great deal of interest around this and in making it work. I'm determined to see it work, and other countries will follow suit.
Thank you. Navnet.
Minister, my question relates to delays. Delays in asylum seeker receiving financial support, identity cards, and scheduling interviews, etc. What are you doing about this particular matter when it relates to putting asylum seekers in very vulnerable situation? What is the government's plan on these particular matters?
In terms of the process, and please, if you have any specific examples, please do give it. But of course, there is the 28 days is the initial. I don't know if that's the angle that you're driving at in terms of the 28 days. My lord, is that the...
That's the basis.
That's the basis of your question. Well, it's important that the government does this. I wonder if my colleagues have any more data or detail on that, but it is the 28 days. I think that your lordship's interested in.
As we're a bit tight for time, I think we might get you to put any data on that in writing.
Is there anything quickly that you could give?
Well, I mean, if the question is, as we grant asylum and get the biometric residency permit to individuals before they leave accommodation, the timing of the 28 days notice before the notice to quit only starts at the point at which the BRP is issued. We're doing a lot of work internally to make sure that process is as efficient and as clear for individuals as it possibly can be. But if there are more detailed questions, or if you were driving at something else, please, we'd be very happy to answer questions.
My second question would be relating to children who come to this country. Mm-hmm. What is the process in dealing with them, particularly bearing in mind that if they don't receive the proper resources, the question of destitution and moving away from structure is very important.
In terms of accommodation specifically, that's a very important point. And there was, as your lordship will know, there was litigation last year in relation to accommodation, and I can confirm to this committee that there are no longer there's not a single hotel that is now open for unaccompanied asylum-seeking children. The final one, there was one open, one left open over the new year. The final one closed on the 31st of January. We looked at the judgment, which I think came out in July of last year. Incredibly important. And may I say, the work that we do with Kent County Council is hugely important as well. I'm very conscious that our colleagues in Kent are doing an incredibly important, and they have an incredibly difficult task in relation to children. But my view is that unaccompanied asylum-seeking children should not be kept. The right and proper and appropriate place is not in hotels. That accords with the judgment of the court, and we've fulfilled our obligations in that regard, and we must continue to cooperate with our colleagues in Kent to make sure that we don't revert to that position, but that children are where they should be within local authority care.
Yeah. And if I may just add as well, we are also working very closely with the Department for Education and indeed with local authorities around the country to make the national transfer scheme work. So the way things work to make sure that we have got children under the statutory care of local authorities is they come through Kent, but then through the national transfer scheme we find placements across the country. And that work is underway, and we are successfully moving children through that process so they're under proper care in local authorities around the country, and that is a sort of cross central local government effort.
How many are we talking about?
You will have to
There were 8,890 children placed in the National Transfer Scheme last year.
Thank you, and well done for meeting what the inspectorate asked you to do, and that's to get all children out of the hotels. So thank you for that.
I want to bring in Lady Mayor now, Catherine.
Yeah. First of all, I want to also second what my noble friend has said, that I'm really welcoming the idea and the fact that children are no longer in hotels. I mean, that was a very, very important thing. The other thing I want to say is that actually I don't agree that other countries are more welcoming than we are. I know France very well, and I know Germany very well. And I can say that, first of all, they themselves have a huge problem, probably bigger than ours. And at the moment, illegal migrants into those countries are actually having a tougher time than they're having in this country. I just wanted to say that. As you've heard, some of us, in fact, 5 of us in this committee, went to Rwanda, and our purpose was really to examine what was going to be the accommodations and how were people going to be received in Rwanda. And many of the people who we interviewed said, we're very positive. Some people were less positive. We all had a very different view of how we saw the situation. But what I would like to ask you, Minister, is what is your assessment of what the government of Rwanda did to take into account all the criticism of the Supreme Court, and in particular the non-refoulement? Has that been actually totally dealt with?
Thank you, and I'm very grateful to your ladyship for that question. But may I say that in terms of the accommodation, can I tackle that first? That's detailed and set out in the treaty, and I know actually it was very helpful evidence that this committee gave, and certainly fed into the second reading and the committee stage debates, because there were differences and nuances, as you'd expect. You wouldn't expect 10 witnesses to say an identical thing, and 5, no more would you expect that either. And I found that personally, as the Minister taking the bill through, very helpful. In terms of non-refoulement, the answer is in the treaty. The treaty is incredibly detailed, whether it's on accommodation, whether it's on the asylum system, whether it's on non-refoulement. So Articles 10, Articles 11. There is the lock, and actually the report of the committee, and if I could find the right paragraph, I'd read it out word for word, but I'm going to paraphrase because I won't be able to find the right paragraph. But the committee accepted that if this works as designed, that it does shut out non-refoulement. That's not word for word, but that's the gist of what this committee's evidence was. This committee. This committee
hasn't actually reported yet.
No, forgive me. Specifically in relation to the Safety of Rwanda bill.
But we haven't reported yet on our visit. We'll do that.
No.
As part of the report, we're going to ultimately produce on our rights of asylum seekers in the UK. So you're right that during the various debates in the Commons and the Lords, individuals who'd been on the trip, including myself, Catherine, gave our different perceptions. But the committee as a whole has not yet deliberated on our trip to Rwanda, so I'd want to be very clear about that.
We are as one. I was referring to the Safety of Rwanda Asylum and Immigration Bill, second report of the session, dated the 7th of February 2024, to which I responded in March, in which the committee very clearly said, as one of its conclusions, that if this works as drafted by the treaty, then it will stop non-refoulement. It was then nuanced. There was a havering, there was a doubting as to whether it would work. But I have no doubt, because this is an international agreement between 2 grown-up Commonwealth countries who, and you look at Rwanda's track record as well in terms of welcoming 135,000 refugees over its borders, and that's exactly why Articles 10 and 11 in this treaty were drafted in the way they were, in order to fulfil the obligations, to fulfil the challenge, if you like, that the Supreme Court set out. So some in the debate, Madam Chairman, I disagreed with the assertion that this was countermanding what the Supreme Court says. Quite the opposite. The words I use, fulfilling, actually fulfilling, saying this is what's happened since the summer of 2022. Look at the treaty. Look at the international binding document between our 2 countries, and this is how we can show that non-refoulement will not happen.
Okay. Do you accept there's certain things that have to happen in Rwanda before the treaty is fulfilled? So, for example, when we met with the UNHCR, they told me that systemic and structural change needs to happen in Rwanda, and then it needs to cascade down through the system. So the treaty envisages that certain things will happen, but they haven't necessarily happened yet. Do you accept that, Minister?
Well, no, I think all necessary, no, not I think, I know, all necessary steps that need to be taken in order for each of our country's obligations to be met have been met. That was the commitment that was given at the time that the bill was passing through. And so, for example, we see in the treaty set out in the Annex B, the system that will be up and running. You heard, the committee members of the committee heard, Madam Chairman, the evidence that Rwanda now has the relevant legislation in place. The co-presidents are in place. This is all up and running.
We also heard that the training has only just commenced. There's a lot of training still to be done. And of course, there is a difference between dealing with an asylum seeker and dealing with a refugee. But I'm conscious of the limited time, and I want to make sure that Jill gets a chance to come in, because she was on the trip to Rwanda, and because we're not going to be able to go on for as long as we'd hoped. I want to make sure that Jill gets a chance to come in. Jill.
My question actually is something that I thought about while I was sitting here. As you know, I had a tragic murder in Hartlepool by someone who was here seeking asylum. That individual had been turned down for asylum. He was a failed asylum seeker in Germany and been in the asylum system for years around Europe. I'd just like to know what steps you are taking to enforce the removal of people who have been turned down, and also the vetting process to make sure that these almost queer asylum seekers aren't bouncing around in Europe and then coming across to us. Because clearly, you know, what's the vetting procedure to make sure that we haven't got dangerous extremists, you know, living in our communities?
Thank you very much. That is an incredibly important question. In terms of failed asylum seekers, I mentioned the figure 26,000 people, those are returns from last year, not all of them. So 26,000 was the total, grand total. In terms of failed asylum seekers, it's been confirmed that the scheme for Rwanda will extend to include failed asylum seekers as well. So that's an important step. I think, to be done sensibly, sensitively, and in a grown-up fashion, but that has been confirmed that will happen. And I don't know, Madam Chairman, whether the committee has had a chance to visit WesternJet Foyle and Manston. I can't remember, some committees have, some haven't.
We did visit Manston a couple of years ago.
Thank you.
Or a year and a half ago. It was quite a while ago.
And things will have changed on the ground because they change rapidly, but there are, for example, equipment, technology in order to take biometric data, just to cover exactly the point that you were making in terms of knowing who is coming in, knowing in terms of safety and security and checks and the like. And it is incredibly important that is done. And it's expanded as well. Certainly on the occasion that I was there, it had expanded as recently as that month in terms of the capacity for taking that, because as the committee knows, it's important for people to be processed in Manston swiftly so that there are no delays at that stage, and there'd be an expansion there. Was there something?
I was just going to add, and we can put more detail in writing given the pressure on time, but more broadly to the question, we're also increasing the overall capacity we've got for removals, both in terms of increasing our capacity in detention centres across the piece, and in terms of the caseworkers we've got in our removals teams to enable us to continue. We've increased the number of removals year on year over the last few years, and we need more capacity to be able to continue to do that.
That's very interesting, and we will follow up in writing with some questions about detention. Sorry, Jill.
If I could just ask another question that sort of tags on a little bit to that. When we're talking about short-term holding facilities, and some people were kept in excess of the amount of time that they should have been, which violated their rights, and there was a risk that they were going to actually sue us, I think, because they'd been kept overly long in the short-term holding places. So I wondered if you had any figures on that. This is probably something that you could reply in writing, figures on that, and some explanation of why that's happened, why they haven't been processed through first.
If I could just tackle that more broadly, and then if there are more specific questions, it would be interesting to hear of the specific examples that you've got if you want to follow up in writing on that. But there are strict time limits, and for obvious reasons. And for example, in relation to Manston, unless there are exceptional circumstances, 24 hours, 72 hours, so that is where we are. But I'm bound to say that certainly since I've been in post, I get a regular report as to how swiftly people are being processed at Manston. And I very much hope, Madam Chair, that you and the committee were impressed by what you saw at Manston in terms of the speed that people were being processed. Perhaps you weren't. Let me say, when I was there, I was impressed by what I saw in terms of what had expanded and the capacity to make sure that our obligations were.
I think I'm the only person left of the group who went.
Oh, fine.
We did did report on it in some detail,
Yeah.
but we had no doubt that there were many decent people there trying to do a good job. And we were impressed by some of the staff we met with, but we still had some grave concerns, but that was the matter of another report, and it's probably something we'll follow up on with you in writing. Catherine, you wanted to come back in
I just
there.
wanted to come back on my question. I mean, how can you sort of convince the people who are not convinced that Rwanda will abide by the terms of the Supreme Courts, and particularly on non-refoulement? Is it going to be by experience, or how can you prove?
Well, my lady, if people aren't convinced now, I suspect it will have to be by experience. But my answer is because of the treaty in the first place, because of the bill and the Act of Parliament in the second place, and because of the steps that Rwanda already have taken and are taking as well. And I think no one can doubt the generosity of the Rwandan people. The debate was sometimes frustrated me. Because the generosity of the Rwandans in stepping forward, and this isn't just a migration plan, it's an MEDP plan and economic development plan. It is the whole picture that we need to take into consideration. 135,000 refugees welcomed by Rwanda, taken from Libya and elsewhere. Okay, not exactly the same. We've had this debate in Parliament. Not in exactly the same situation, not exactly the same, but it's an indication of how seriously Rwanda takes its obligations in this regard. And I have no doubt that the treaty is a step up. It's an internationally binding treaty. And frankly, through some of the debate that we've seen, we've now got a treaty, we've now got an Act of Parliament, and now we need to get on and do it. And that's what I'm determined to do.
Very quickly, Helena, because I think we're about to have run out of time.
This is rather important because, Minister, you keep repeating that there have been such terrible misconceptions. But Rwanda, as you know, is right next door to the Congo, where a civil war has been going on. And many of the people, forget Libya, the numbers from Libya are not the significant ones. The significant numbers are people from the Congo who have fled the destruction, the mass rape, and the terrible violence that's taking place currently inside the Congo. And they're not living in nice accommodation, they're living in terrible camps on the outskirts of Kigali, which of course were not part of the designed tour available to our members of Parliament. Right. And so this distinction has to be made, which is most people in Africa, are, when they're fleeing terrible wars, flee to the next door country, and Rwanda has had that experience and has encampments of those people. Now, we have chosen to do something differently, and we have helped building, and we've invested a lot of money in creating accommodation. And you see, the point I was making to you, which is that when you say that, that they're going to take 2,000 in the first year, up to 2,000, and then each year thereafter, so over 5 years, 10,000, right? So far, the accommodation Hope Hostel is providing accommodation. I said 100, and forgive me, I was wrong. I've just checked, and it's 200. And so the accommodation is still a serious issue if we don't want them to be intense in the outskirts and facing the deprivations involved in that. So if we're going to provide accommodation, it involves continued investment and sending of money to Rwanda, which I have no doubt Rwanda's happy about. But the question I've got for you is, if you even get up to 10,000, we know that there was talk of 52,000 eligible contenders for places on the Rwanda scheme. 52,000. Well, Rwanda's not talking about taking 52,000. They're talking about over 5 years taking 10,000. So what are you going to do with the 42,000 that are left over? What's going to happen to them?
Well, Maidi, that picks up on a point that, Madam Chair, you raised early on. But in terms of the accommodation, you're right, Maidi, this is different. And Annex A to the treaty sets out in detail, in granular detail, what the accommodation, the fulfilments that are required for the accommodation, support on arrival, for the reception, etc., etc. Very different, you're right. I think I illustrated the 135,000 to show the spirit, the generous spirit and nature of the Rwandan people, rather than saying it's an exactly comparable scheme, because it's not. This scheme is a bespoke scheme with a treaty between two international partners, and that's why I have confidence in it. In terms of the returns, not all will be returned to Rwanda. Not all have to be, because some will be able to be returned to their home country. So as I explained last year, 26,000 people were returned by this country to their home country, to their country of origin. As Mr. Ridley indicated, I think, if I remember correctly, that has increased in recent years, and we need to make sure that continues to increase. But the whole purpose, forgive me, the whole purpose of the Rwanda scheme is to act as a deterrent so that we stop the boats. It is not just a question of what is the biggest number you can think of. It is, in fact, stopping the boats. That is the determination.
I want to persist with my question, which is that there are 42... If your numbers are right, and I'm relying on your numbers, then you have a huge backlog of people who are going to still be here. And I wanted your answer to what are you going to do with them? You're talking about deterrence for people coming.
That's the key to the scheme, that's right.
What are you going to do with the many thousands of people who are currently here? You're talking about sending them back. How do you send them back if they're from places where sending back is not a possibility? What are you going to do?
They'll be returned to their home country or to a safe third country such as Rwanda. So the Rwanda scheme, you're absolutely right, is to fulfill two purposes. Its primary purpose, in my view, is to ensure that the deterrent effect kicks in to stop the boats. Therefore, even more people are not added to the lists that you quite rightly highlighted, because that is the important, that is the fundamentally vital factor of this bill. That's why it is important. And as to the others that are already here, it is a mixture of a safe third country if they are not able to be returned to their home country.
Given that Rwanda has said that they will only be able to take 10,000 for 5 years.
I think you've had your shot.
No, yes. I want to just ask, what are you going to do? Which countries? How many countries have you got lined up to do the same Rwanda thing?
Madam Chairman, respectfully, I don't think my answer is different.
Of course. Just pause there. Of course. I'm very conscious that we're going to have to finish in a moment. And these are very important issues, and what I'm going to do is I'm going to follow up on Helena's question in writing.
Please.
Respectfully, my answer isn't going to be different from the one that I've just given.
I understand that, but we will follow up on it, because that's what I want us to do. But I want to bring in Jill quickly, and then Simon, and then I'm afraid we'll have to wind it up. I think that's right, Jill, yes.
There's three things I want to... Because we were there and we spoke to the people. Hope Hostel is just a processing short-term centre. We saw a lot of accommodation that's been built to take people once they've gone through there. When we spoke to the Rwandans about the limits of the scheme, they don't see any limit. They don't have any limit. They said, we will take whoever you want to send, as many as you like. And
that's not what I was told by the government.
They said it wasn't limited.
Uncapped scheme.
It's uncapped. And thirdly, the terrible condition of the Congolese people, the people live in camps. The Rwandans have attempted to settle them into their communities, but there's a reluctance between a lot of them because they actually want to return to their homes. And they feel that if they leave the camps, we were told that if they leave the camps, it's like a step away from ever being able to go home.
We're all agreed that the refugees in the camps who've come across the border fleeing a civil war and the most appalling violence are in a very different category, and we don't have time to go into that just now. So I want to bring Simon in, and then we'll need to wind things up.
Just a very short question. This is about the asylum grant rate disparity. In the United Kingdom, asylum is granted in about 75% of applications. In France and Germany, it's nearer 20%. Will you get the Home Office to investigate the reasons for that disparity and see what policy steps might be taken?
My Lord, that's an incredibly important question. The latest figure is lower than 75%. I hope it's 67%. If it's not, I will confirm in writing, but it is moving down and moving lower. The short answer to your question is that it's not exactly precisely comparing like with like, and there is always a challenge with comparing international statistics. But Madam Chairman, with your permission, may I reply to that question in further detail in writing, because it is an important point, and it's certainly my determination that that figure continues to move down from the 70s where it was. It is now 67 or thereabouts, and it needs to be moving in that direction.
When you provide that information, Minister, earlier on you talked about children.
Thank you.
There are missing children, of course, within the system as well. I wonder if you can give us the current figures on that when you come to reply, and what action we're taking to locate those children who remain missing.
My Lord, if I'm prompted to do so, I will certainly do that.
What we'll do, Minister, in fairness, because this session has been shorter than we hoped it would be, and we're grateful to you for your forbearance and for coming a bit earlier. What we'll do is we will, as a committee, generate a document to you listing the additional questions that we want to ask you in writing, so that we're quite clear what they are, and members can contribute to that through the usual channels. We'll have a quick chat about that.
Yeah.
Sorry, Ms Rowland.
That's okay. I just wanted to clarify it is indeed 67%, but that is on old immigration legislation. So this year's figures, once we've processed new casework, will be on the Nationality and Borders Act. That's got a different evidential threshold, so we would expect to see some difference.
Let's come back with further detail, but thank you.
Right. That's a very interesting point. Thank you for drawing that to my attention. Thank you very much indeed. Very interesting session. I'd love for us to have longer, but as I say, we will follow up in writing. And
Goodness for civil servants.
thank you to your colleagues as well. Thank you. I draw the meeting to a close. Order, order.